years. My points today are the result of a collaboration between lawyers who oppose this curriculum. We have a petition for you that have been signed by 468 Alameda residents, which you can view at this time, but we would like to collect it back due to fear of retaliation should those names be made public. We also have extra copies of an alternative resolution previously submitted to you that you could choose to put forward to go along with your no vote. If the board adopts this curriculum today, it will expose our schools to costly legal liability. The curriculum's proponents have not cited a single incident when a school district rejected an LGBT curriculum and was even sued, much less lost the suit. AB 537 says, quote, "Nothing in the Act requires the inclusion of any curriculum in any program or activity conducted by an educational institution. The law also says it is not violated by the omission of any curriculum." The only scenarios when a school district has gotten in legal trouble all involve a long-standing pattern of repeated harassment, as well as both knowledge of the harassment and inaction by school officials. No evidence of repeated harassment in Alameda's elementary schools has been put forward, nor are there statistics showing bullying on the grounds of sexual orientation. There is no evidence to suggest that the district's current non-discrimination/harassment policy, which protects kids from any and every form of harassment, is inadequate to address alleged LGBT bullying. AB 537 warns against singling out LGBT and recommends integration into generic safety training. Why are we going against the recommendation of the law by relegating the other protected groups into a background teaching support guide? We don't have to blindly follow the city the consultant we are paying came from. For Alameda, our policy is all we need. On the other hand, if the board adopts this curriculum, it will expose our schools to costly legal liability. Several other attorneys have already presented forceful arguments about the various state and federal laws the curriculum will violate. I would just like to focus the board's attention tonight on the fact that the staff have refused to include an opt-out provision in the curriculum. Since the curriculum constitutes health education, for which California law gives parents the right to opt out, the curriculum will violate California law. The curriculum supporters found a few lawyers who wrote a letter saying the curriculum is not health education, quote, under any commonly understood meaning of the word, unquote. With all due respect, the definition of health education is not to be decided by a bunch of lawyers or by this board. The legislature asked the State Board of Education to define health education. Under authority of law, the State Board defined health education to include, among other things, all lessons on, quote, the characteristics of families, how members of a family have various roles, responsibilities, and individual needs, and individual differences in gender roles. The supporters' lawyers candidly admit the curriculum falls well within these definitions. We have every confidence that a California court judge, reading the plain language of the law and the State Board's definitions, will agree that indeed this curriculum falls within the definition of health education. In the end, the board's choice is simple. You can reject this curriculum until the staff submits it with an opt-out clause, or you can adopt it and continue to hear from the numerous upset parents of this community and their lawyers. After a bitter court fight, injunctions, and sky-high legal fees, we'll be right back at square one with an opt-out clause. The staff's recommendations as presented today are inadequate. We in Alameda would like to work together to create a common ground task force for K through 12 as outlined in the resolution. Thus, we respectfully request the board to reject this curriculum and vote for an authentic community solution. Thank you.